Hey guys, thank you for coming back to Chapter 9, Construction Lien Law. This is the 2021 Florida Contractors Manual. And the first thing we want to highlight in the table of contents is construction lien law not applicable to public owners and public property. Another thing is, what is a notice of commencement? Another one is, am I a liener? And that's pretty much it. Those that I highlight are usually from questions that I couldn't find in the index, so I highlight them there. And the first page we want to go to highlight is page 9.8. We want to go to what is a construction lien. A construction lien is a claim of charge against real property and the improvements thereon to secure debt incurred for the improvement of that property. First element, debt incurred to improve property. Second element, compliance with procedure. Page 9.9, we have under do I need a license? Under Florida law, if you enter into a construction contract and the work you are undertaking requires a professional license, architect, engineer, etc., or it requires a contractor's license, failure to have that license renders the contract void from the start. Down below, licensing and chain in linear. If a contractor is not licensed in a jurisdiction where a license is required, any contract with that purported contractor, subcontractor, or subcontractor may be void pursuant to Florida Statute 489.128. Down below, we have the notice is not required in the contractor or subcontractors that are not directly with the owner and is not required for construction of other residences. Next page, we have 9.10, property owned by married persons. The only exception is if the non-signing spouse, gives to the contractor and records in the clerk's office notice of his or her objection within 10 days of learning of the contract. If you are working for the developer or the condominium association on the entire project or the common elements of project affecting multiple units, for example, roof, pool, parking lot, exterior walls, etc., then you have a lien against all the units in the condominium project. Note that if you work on common elements, you do not have a lien on the common elements, but you do have a lien on the units. This is addressed in the Condominium Statute, Chapter 718, Florida Statutes. Then we have page 911. We have small direct contract exemptions. You should know that if the contract price in the contract between an owner and a contractor is $2,500 or less, then the only person who has lien rights is the contractor. If the contract price for repair or replacement of HVAC system is $7,500 or less, no notice of commencement is required. Construction lien law not applicable to public owners and public property. If you are working on a project that is owned by any unit of government, then the construction lien law does not apply. If you are improving real property that is owned by an agency of the federal government, you may have a remedy under the Federal Miller Act payment bond. Page 912. What is a notice of commencement? Duty to record and post notice of commencement. If there is a no construction loan, then the owner has the duty to record the notice of commencement in the public records of the county where the real property is being improved before work on the real property begins, but no sooner than 90 days prior to starting work at the site. If there is a construction loan, the recording of the notice of commencement is the lender's duty. The owner is obliged to post a copy of the notice of commencement at the job site regardless of who records the notice of commencement. Page 913, time to record notice of commencement. The notice of commencement is to be recorded before construction starts, but not sooner than 90 days before construction starts. Page 914, we have duty to keep notice of commencement effective during the entire job. If no date is filled in, then the date is 1 year from the date the notice of commencement is recorded. A notice of commencement may be amended before it expires to extend the expiration date. Next paragraph, note also that any payments made by an owner after expiration of notice of commencement are improper payments and do not reduce the owner's exposure for liens, such that the owner may be obliged to still pay the liener up to the amount of the improper payments. So during the exam, guys, you will most likely get a question about notice of commencement, and you can easily find this on the index, and that'll take you straight to this section. Page 916, amendment of notice of commencement. If there is an error in the notice of commencement, or if a job takes longer than originally anticipated, it would be proper to amend the notice of commencement. The error could be corrected, or the effect period of the notice of commencement could be extended. Now, I want to point out, guys, that while you're taking your exam, it's important to do the highlighting because they changed they changed the questions. So the more you have highlighted, the better. That way, when you go through these questions and you go to certain topics, the first thing you want to look at is the highlighted portion to see if the answer's in the highlighted portion. If not, look around it. But more than likely, guys, the more you have highlighted, the better you'll find these answers. Page 918. We have, in the event that there are insufficient funds from contract price to pay all valid liens, the liens attaching at the same time, those attaching as of notice of commencement, take priority as follows: liens of laborers, liens of everyone else except the contractor, lien of the contractor. So the contractor is the last one. Am I a liener? A material man or material supplier, someone who contracts to furnish materials to the owner, contractor, subcontractor, or subcontractor, and delivers directly to the site or sells direct delivery to the site, or who makes special manufactured materials specifically for the job, not readily usable elsewhere, and performs no labor in the installation. And the next one is, the following list describes the proper lieners: subcontractors or material suppliers selling to subcontractor, material supplier selling to subcontractor, labor performing personal labor on the job for an owner, contractor, subcontractor, or subcontractor. Obviously, it's all 6, but these are the main ones that I have seen during the exams. Page 919. Note that a material man selling to another material man is not a liener. That's very important. Note that a subcontractor is not a liener as well. So during the exam, they might ask you which of the following describes non-lieners. So make sure you guys go through this 3 times at least. Continuing on page 919, what work is lienable? The statutory definitions of improve and improvement clearly include one would ordinarily consider construction work on the site, for example, structural work, plumbing, electrical, mechanical, etc. Solid waste collection and removal is a lienable improvement. Page 920. Purpose of notice to owner. It gives the sender of the notice the right to participate in payments from the owner, and the owner receives the notice. Even though the sender of the notice to owner does not have a contract directly with the owner, it gives the owner the duty to see that the sender of the notice is paid to the extent that the owner pays the contractor. Page 922, we have time. If you are not dealing directly with the owner must receive the notice to owner with a copy to every person in chain of contract between your customer and the owner not later than the earliest of the following times: 45 days from the liener's first work at the site, or first delivery of materials to the site, or the beginning manufacture specifically fabricated materials wherever they are being manufactured. If there are specifically fabricated materials being furnished by the liener, not including the preparation of sharp drawings, or B and C. Also note that a non-privity claimant, one who is not selling directly to the owner, has no lien rights until he or she serves the notice to owner. Next paragraph. If you are in privity of contract with the owner does not need to receive a notice that you are working on the real property. Privity. This is very important, guys. They will ask you a question about this topic, so make sure you go over this. Privity of contract has been defined as the connection or relationship which exists between two or more contracting parties. And I would read the whole paragraph just so you can understand it more. Going on to page 923, how do I serve the notice to owner and other lien documents? Actual delivery. Common carrier delivery, global express guaranteed delivery, or certified or registered mail with evidence of delivery, return, receipt. Page 924, we have certified or registered mail delivery with first 40 days, no receipt, posting at the job site, released through a time certain. This is the release that releases all lien rights through the date recited in the release. We have a skip until page 928. We have, in order to deal with this potential situation, a liener may do one of three things: A, B, and C. Make sure you guys go over those. The claim of lien. The claim of lien is the document that is recorded in the public records of notice to the world of the claim of liener against the property. The claim of lien is described in Florida Statute 713.08. Notice the following about the claim of lien form. And then you have 1 through 9. One of the ones I saw is the value of work done, materials furnished, and the amount remaining unpaid for the performed work. Not unperformed work must be in the claim of lien. Last paragraph. The claim of lien must be recorded in the county where the improved property is located not later than 90 days. Make sure you guys circle all the numbers once again. That will allow you to find the answers quicker when it involves numbers. In the case of someone working under a contractor who has been terminated, the lien must be recorded within 90 days of termination of the contractor, if sooner than 90 days from the last work. The lien must be recorded by the clerk. That's important as well. Within 90 days, not just delivered to the clerk for recording within 90 days. Okay, page 931. This is another very important page. Serve a copy of the claim of lien on the owner. You will definitely get a question about this. When a liener records a claim of lien, the liener should serve a copy of claim of lien on the owner not later than 15 days from recording. How long does a claim of lien last? A claim of lien is effective for 1 year from the day on which it is recorded. The lien or must take action to enforce the lien by suit within that time, or else the lien will expire by operation of law and will no longer have any legal effect. Last paragraph, which says caution, notice of contest of lien. The owner may shorten the time to enforce the claim of lien by recording a notice of contest of lien. Only the owner or the owner's attorney can sign the notice of contest of lien. Page 932. Lieners must be careful to avoid losing lien rights as a result of copy of notice of contest of lien if the liener fails to file a lawsuit to enforce the lien within 60 days of the date of the clerk of courts certifies and the notice of contest of lien that a copy was served on the liener. Lien rights are lost. 20-day summons to show cause. The effect is to shorten the effective period of the claim of lien 20 days after service of summons, unless the liener files a counterclaim or separate suit to enforce the lien. Page 934, we have requests from owner for list of subs and suppliers. The contractor must, within 10 days after receipt of owner's written request, furnish to the property owner or his or her agent a list of subcontractors and suppliers who have direct contract with the contractor as of the date the request is received by the contractor. Demand for a copy of contract. There is no specific time period for responding to the request for a copy of the contract. Thus, the response is due within reasonable time. A reasonable time is not subject to exact definition. However, a period of 30 days or less would appear to be reasonable in most circumstances. Page 935. Schedule of values shows the value of work that the subcontractor is performing to be approximately half of the contract price that the subcontractor and the contractor agreed. Okay, we have on page 937, we have sworn statement account, 30 days. That's something you guys want to try to remember. 938, contractor's final payment affidavit. This is something that I definitely saw in the exam. The statute says that the contractor must, in any event, give the owner a final contractor's affidavit not later than 5 days before the contractor files suit to enforce the contractor's lien. We have failure to pay undisputed sums on page 941. If a liener or owner fails to pay undisputed sums to a liener where the unpaid liener has performed all duties under the contract and the lien law so as to be entitled to payment for a period of 30 days, the unpaid liener may seek equitable remedies and obtain hearing by filing a complaint pursuant to Florida Statute 713.346. Alright, continuing on page 942, fraudulent lien. A person who willfully files a fraudulent lien is guilty of a felony of the 3rd degree. Misapplication of contract construction funds. If a person knowingly uses funds paid on account of a particular job without paying the funds to subs, suppliers, and or laborers whose funds are due for the work paid, is guilty of misapplication of construction funds. This crime is a felony. Page 943, satisfaction of lien. Once a claim of lien has been recorded and resolved by payment or settlement, the proper documents to a given and recorded in the public records is satisfaction of lien. We have page 946, the amount of lien transfer bond. 100% of the lien amount plus interest at the legal rate for 3 years. C. The greater 1,000 or 25% of the lien amount for costs and attorney fees. We have page 947. Once the lien has been transferred to bond, the state circuit court, not the county court, may have exclusive jurisdiction over an action to seek payment on the lien transfer bond. Page 949, Federal Public Works Payment Bond, the Miller Act, 40 U.S.C. 3131. Contractors on most federal public work projects are required by federal law to post payment and performance bonds. The federal law that requires this is called the Miller Act. Procedure: claimant selling to bonded contractor. The Federal Miller Act requires that all parties are in privity of contract with the contractor must file suit in federal court to sooner than 90 days and not later than 1 year from the last date that they furnished labor, services, or materials to the job. Page 950, we have state, county, or municipal public works payment bonds. Because these are similar in concept to Federal Miller Act, they are sometimes called Little Miller Act bonds. We have a skip here. See. So the next one, guys, is a book within a book. This is chapter 713. Liens, generally construction liens. And the answers that I have gotten from this is liens of persons not in privity, proper payments. 713.08, claim of lien. We have 713.6, demand for copy of contract and statement of account. We have 713.22, duration of lien. 713.24, transfer a lien to security. 713.346, payment on construction contracts. So on page 971, we have a material man or laborer, either of whom is in privity with the owner. Page 972, we have liens of persons not in privity, proper payments. A material man to a subcontractor. Let's see if I can. Says a material man to a subcontractor shall serve the notice to owner on the subcontractor if the material man knows the name and address of the subcontractor. The notice must be served before commencing, or not later than 45 days after commencing, to furnish his or her labor, services, or materials, but in any event before the date of the owner's disbursement of the final payment after contractor has furnished the affidavit under sub-paragraph. Page 973, we have letter D. A notice to an owner served on a lender must be in writing, must be served in accordance with Statute 713.18, and shall be addressed to the persons designed, if any, and to the place and address designated in the notice of commencement. Any lender who, after receiving a notice provided under this subsection, pays a contractor on behalf of the owner for an improvement. Contractor, that's it. Well, shall make proper payments as provided in paragraph. See what we have. Page 976. We have number 5. The claim of lien may be recorded at any time during the progress of the work or thereafter, but not later than 90 days after the final furnishing of labor or services. The claim of lien shall be recorded in the clerk's office. There it is again. Page 978, we have letter C. Any payments made by the owner after the expiration of the notice of commencement are considered improper payments. This is a very important one. Page 979, notice of termination. We have A, B, and C. C is a statement of the date as of which the notice of commencement is terminated, which date may be earlier than 30 days after the notice of termination is recorded. 980, notice of commencement and application of lien. A notice of commencement must be recorded and posted on the job site before the first inspection. We also have on the next side of the page, if the direct contract is greater than $2,500, the applicant shall file the issuing authority prior to the first inspection either a certified copy of the recorded notice of commencement or a notarized statement that the notice of commencement has been filed for recording. Next thing is 983. The failure or refusal to furnish the statement under the oath with 30 days after the demand or the furnishing of false or fraudulent statement deprives the person so failing or refusing to furnish such statement on his or her lien. Let's see what else we got. Page 986. Number 4. By an order of the Circuit Court of the county where the property is located, as provided in this subsection, upon filing a complaint thereafter by any interested party, the clerk shall issue a summons to the liener to show cause within 20 days why his or her lien should not be enforced by action or vacated and canceled of record. 713.22 Duration of lien. A lien provided by this part does not continue for a longer period than 1 year after the claim of lien has been recorded, unless within that time an active to enforce the lien is commenced in a court of competent jurisdiction. Page 989, we have B, and the clerk shall be entitled to service charge for making and serving the certificate in the amount up to $20, from which the clerk shall remit $5 to the Department of Revenue for deposit into the General Revenue Fund. We have a little skip here until page 994. Payment on construction contracts. Any person who receives a payment for construction or altering permanent improvements to real property shall pay in accordance with the contract terms the undisputed contract obligations for labor, services, or materials provided on account or such improvements. And that's it for chapter 9. The next one we will be going over is chapter 10, the final one. Thank you guys.